California is one of the more aggressive states, as many of you know, on the employment front. And this year is no exception. There's been a number of new California employment laws, and what we've done here is distill what we think are some of the essential laws that employers should know in California going into 2019. We'll also address some new case developments that are particularly relevant to California employers, and then lastly provide some practical tips for you all. The webinar is an annual event that our firm does on California developments. California this year has really, it's been no exception. There's been quite a number of new laws, and we have a new governor in California, Governor Newsom, and we'll see what happens next year and whether there's a change in the degree of regulation within our state. Our firm, Carve, we're a boutique labor and employment firm. We do both employment litigation and counseling as well as OSHA defense. And we have an active presence in California as well as throughout the nation based in Washington, D.C. Just very briefly about myself, I'm a partner with the labor and employment practice in California, where I focus on advice and counsel of California employers on a variety of California employment issues, whether it be leaves of absence, personnel actions, or wage and hour issues. And then I litigate employment cases throughout the state in both Southern and Northern California, and then represent employers in Cal OSHA enforcement proceedings as well as in various OSHA proceedings and other state plans. And I'm pleased to be joined today by my colleague Beeta Lashkari, and I'll let Beeta introduce yourself here.
Thanks so much, Andrew, and welcome everyone. Thanks for being with us today. My name is Beeta Lashkari. I'm an associate in the Labor and Employment and Workplace Safety Practice Groups at Carve. My work is primarily in managing workplace investigations and defending employers in EEOC discrimination and harassment claims. I also counsel employers on sort of all types of workplace legal issues and represent them in the full range of matters, both on the labor and employment side and workplace safety side, primarily under the OSH Act. I also manage inspections and investigations by OSHA, the Chemical Safety Board, or CSB, which is where I came from prior to starting with the firm, the EPA, and other federal, state, and local agencies. I'll hand it back over to Andrew to continue with the agenda.
Thank you, Beeta. I wanted to cover briefly the agenda for today. There are a number of new California employment laws and regulations, the latest wave this year, and we've distilled it to the key new employment laws impacting private sector employers in the state. We're also going to address the new minimum wage ordinances. There's a number. It's been constantly expanding, not just the California state minimum wage, but various municipalities that have their own minimum wage, and those have had step increases. So Beeta will be discussing those minimum wage ordinances. And we will also discuss various key case developments and discuss the essential aspects of those cases and how they will impact you directly doing business within the state. And lastly, we will cover practical tips and best practices for compliance. So based on these new developments, what should you be looking out for as employers? So let's start off with, we have the major California employment laws, and the Me Too legislation has been a huge part of this year of legislation within the state. And there has, in light of the Me Too movement that we're all aware of, which is really formed in the wake of sexual misconduct allegations against high-profile public figures, It has certainly garnered the attention of the state legislature. And there were a number of laws that were being considered through bills in the legislature earlier in the year. And some were problematic and really were not in line with the core concerns of the Me Too movement. And some of them have been stalled in the legislature, and others have been vetoed by the governor. And so briefly before we start, I wanted to just recap those developments. There was one bill, AB 1870, that was seeking to extend the statute of limitations for bringing a charge of discrimination or harassment with the Department of Fair Employment and Housing. That legislation was seeking to extend that time period from 1 to 3 years. That bill was vetoed by the governor. There was also another bill, SB 1038, that was seeking to impose personal liability for retaliation, so that a supervisor or manager that is alleged to have retaliated against could have personal exposure. That's inconsistent with a key Supreme Court ruling, and that legislation was essentially stalled and no action was taken by the legislature. And then a real significant development, AB 3080, that was an arbitration bill that was seeking to place limitations on the ability of employers to require arbitration of harassment claims. That bill was fortunately vetoed by the governor, essentially as stated in his veto message that this bill was seeking to override existing law and was not enforceable. And then lastly, there was a bill, AB 1761, that was seeking, we call it the panic button legislation. It was seeking to require that hotels and other lodging establishments provide housekeeper panic buttons. And there were a number of concerns around the logistics of that, and that legislation ultimately was not acted upon and was stalled in the legislature. But what did make it out of the legislature and receive the governor's signature, there was one significant development over training requirements. Existing law requires that employers with 50 or more employees, regardless of where the employees are located, provide 2 hours of supervisor sexual harassment training. And that training must be provided within 6 months of a supervisor assuming those supervisory duties, or otherwise every 2 years. And then there's a very specific type of requirements that are imposed and what must be contained within that training. And so those of you that have this number of employees know that you have to conduct this training. It's done every 2 years. And the legislature proposed a bill that would significantly expand the scope of this requirement to smaller employers and also training of non-supervisory employees. So let's discuss what this entails. So now any employer with 5 or more employees, that's a much broader universe of employers, they must provide that supervisory harassment training, that 2-hour training that I had just mentioned. But in addition, all employers with 5 or more employees must also provide 1 hour of sexual harassment training to all non-supervisory employees. So this is a real significant expansion of the training requirements. And this training must be provided by January 1st of next year. And so it will be important for you all to consider that for this training, there are a couple of different ways that it can be administered. You can have live training. It must be done by someone that is either in HR field, an attorney, or a instructor at a college or university. Or you can administer online training. It's e-learning or a webinar. But if it's going to be a webinar or e-learning, it has to provide the option for the participant to ask questions and to receive answers. So it can't just be a DVD without any interactive option. And so employers will need to begin this non-supervisory harassment training of 1 hour and have that administered by January 1st of next year. And then smaller employers will need to follow the requirements for the supervisory training. One interesting nuance to this new law is that temporary employees must be trained as well, and those temporary employees must be trained in a relatively short time frame. As indicated on the slide, it's within 30 days after hire or within 100 hours worked, whichever occurs first. And so if you do have temporary employees, you'll want to expedite that training. And the other key Me Too legislation involves confidentiality provisions. As many of you know, when you have a employee separation or a litigation matter that's resolved, you may consider a settlement agreement. And in that agreement, there is typically some sort of confidentiality agreement about the terms of the settlement. There could be other confidentiality terms about what is disclosed about the employment relationship. And that type of clause received the attention of the Me Too movement in that it was perceived as attempting to conceal or perpetuate harassing behavior. So here, this legislation prevents the disclosure or prevents any settlement agreement that bars the disclosure of factual information related to a claim filed in a civil or administrative action. And that factual information must relate to a claim involving sexual assault, sexual harassment under the California UNRRA Act that relates to business relationships, non-employment context, as well as harassment claims occurring in an employment context. So it could be harassment, sexual harassment, sex discrimination, or retaliation for reporting sex harassment or discrimination. And lastly, a claim that would be covered would be a claim related to harassment or discrimination based on sex or retaliation by an owner of a housing accommodation. And so this new requirement takes effect and applies to agreements entered on or after January 1st of 2019. And so if you have a settlement agreement relating to the release of a harassment claim or any of the other claims that are covered under these bullets, that you cannot, under this new law, preclude the former employee or current employee from disclosing factual information underlying those claims. What's important to note is that this new law, SB 820, does not apply to non-disclosure provisions in the agreement related to the identity of the claimant or facts that could lead to the discovery of his or her identity if requested by the claimant. So essentially, if the claimant's asking to have some sort of protection so that his or her name is not disseminated, that's something that could be honored as part of the agreement. And key to this new law is that it does not preclude any confidentiality provision over the settlement amount, which is typically a very important consideration for an employer to pay out a settlement. They don't want the employee sharing that information with other employees and having that encourage further claims. And another Me Too piece of legislation relates to non-disparagement clauses. So many settlement agreements may have some language that prevents the employee from disparaging the employer after leaving. And what this legislation does is it makes it unlawful for an employer to require in exchange for a bonus or a raise or any other condition of employment, the execution of a release of a claim, an agreement seeking to deny the employee the right to disclose information about unlawful acts in the workplace. So essentially, during the employment relationship, you cannot now require that your employee release a claim or right as a condition for remaining employed, or in exchange for any other condition of employment, and you can't bar the employee from disclosing information about unlawful acts in the workplace. And unlawful acts was defined to include sexual harassment and very broadly other unlawful or potentially unlawful conduct. What's important to note is SB 1300 that imposes this restriction on employment agreements does not apply to a negotiated settlement agreement. So you're really talking about an agreement that's entered during the employment relationship typically. And a negotiated settlement agreement, so to flesh this out a little bit more, this law does not apply to a negotiated settlement agreement resolving a FEHA claim, and that's a discrimination or harassment claim under the FEHA that could involve disability or any other protected status, but it would be an agreement involving that claim related to a claim filed by the employee in court before an agency such as the Department of Fair Employment and Housing Act, an ADR forum, or an employer's internal complaint process. And negotiate means that the agreement is voluntary and deliberate and informed and provides something of value to the employee, and that the employee is given notice and an opportunity to retain an attorney or is represented by an attorney. So it's important that now when entering into settlement agreements with employees that you contain some sort of representation about these elements to ensure that you are carved out of the restrictions imposed under SB 1300. There is also a bill, AB 3109, that limits the use of non-disclosure provisions in contracts or settlement agreements that preclude a sexual harassment victim from discussing misconduct when compelled to do so. And by compelled to do so, that's really referring to testimony in response to a subpoena, a court order, or written request from an administrative agency. And so if you have a clause in an agreement that prevents the employee from testifying under these circumstances after January 1st of this year, that is void and unenforceable. Typically, employers will be careful about how they restrict an employee from sharing information in the settlement agreement because there are certain legal processes in which testimony can be compelled, such as depositions or at trial or by an agency. But this law just makes clear that relating to sexual harassment that an employer cannot impose any such restriction. And then another interesting development is relating to defamation claims for sexual harassment complaints, investigations, and references. And so under existing law, any person can be subject to a defamation claim for making what is alleged to be a false statement of fact. And one issue that has arisen often over the years has been in a sexual harassment investigation, the employer is acting in good faith, conducting the investigation, and will receive information that's sensitive in nature, and you want to avoid being the subject of a defamation claim. by the alleged victim or the accused over what is discussed in the context of the investigation and the actions taken. What this law has done is it's expanded the scope of the communication privilege, and essentially for a defamation claim, there is a privilege available for interested parties sharing information without malice. And so that would be typically the situation where an employer is sharing information with supervisors or others on a need-to-know basis about a personnel matter. And the communication must be without malice, meaning that it's not made with any intent to harm or ill will. And so what this law did was it specified that these protected communications made without malice among interested parties concern complaints of sexual harassment by an employee to an employer based on credible evidence, communications between the employer and interested persons regarding a complaint of harassment. And that's particularly helpful when you are addressing a delicate harassment matter and you want to ensure that you receive accurate information, that you are making the right decision. You don't want to then have a claim, in most cases, by the accused because you're discussing these allegations. And the law also authorizes a current or former employer to answer without malice to a prospective employer, whether the former or current employer would rehire an employee, and whether a decision not to rehire is based on an employer's determination that the former employee engaged in sexual harassment. So if you receive a reference check from a prospective employer, that you do have a defense that enables you to share information about that harassment allegation concerning that employee. The caveat, though, is that this has to be done without malice, and that can be a disputed issue in a litigation. But this just provides one additional protection that was a bit murkier before. And another development relates to human trafficking training for hotel employees. And those of you that are lodging establishments will know that SB 970 now amends the Fair Employment and Housing Act to require hotels and motels, but excluding bed and breakfasts, to provide at least 20 minutes of classroom or other effective interactive training on human trafficking awareness, and this is administered to employees likely to interact or come into contact with victims of human trafficking. And that specifically involves employees who have recurring interactions with the public, including employees who work in reception areas, perform housekeeping duties, help guests in moving their possessions, and drive guests. The training must be provided by January 1st of next year. For those employed as of July 1, 2019. And otherwise, the training must be administered within 6 months of any new employees obtaining their positions. And then the training must be provided every 2 years thereafter. There are some organizations that are stepping in to assist hotels in providing this training, or the training can be provided by the hotel through its own program in-house. Okay, so let's discuss now, moving to some developments under the Equal Pay Law. California does have an equal pay law requiring that there be equal compensation under equal working conditions and circumstances, regardless of gender and national origin and race. There have been some clarifications to these laws under these new bills. There's also been in California a prohibition on salary history inquiries of applicants for employment. So the clarifications that have been made under these bills involve essentially clarifying that, well, let me address one thing first, is that existing law requires under the salary history prohibition that an employer, upon reasonable request, must provide a position's pay scale to an applicant. So if an applicant's applying for a position and then wants to know the pay scale, that's something that the potential employer must provide. But under this new law, it clarifies that employers need only provide the pay scale, whether that be the salary or the hourly wage ranges, to applicants who have completed at least one interview. So if it's just an application they submitted, you don't have an obligation to provide this pay information. Once they've gone to the interview stage, then you do have that obligation. And the law also clarifies that, this is AB 2282, clarifies that employers are not prohibited from asking applicants about their salary expectations. That's always been my understanding of prior law, but this just clarifies that point. And then the law also clarifies that an employer may ask an existing employee about that, or that employer may make a compensation decision based on a current employee's existing salary, as long as there is no differential impact on that employee. And so if it's based on neutral considerations such as seniority or merit, it is justified. So now I'm going to turn it over to Beeta to discuss the new Cal OSHA e-record keeping rule that has just passed.
Great, thanks so much, Andrew. So now we are going to switch gears a little bit and talk about California's adoption of the e-record keeping rule. So federal OSHA's rule to improve tracking of workplace injuries and illnesses, which is known as the e-record keeping rule, requires small employers operating in certain high-hazard industries and all large employers to electronically submit injury and illness data to OSHA. Just by way of background, the rule should not be confused with federal OSHA's sort of traditional old injury and illness record-keeping rule. That rule requires all employers, except for a few that are exempt, to prepare, certify, and post internally their 300A summary data for their employees' eyes only. The e-record keeping rule, on the other hand, requires posting to OSHA's online web application. So just to make sure, there is a distinction. They are two separate rules. We have a lot of questions about whether they're the same, so always like to just make sure to point out that distinction. We also, our firm just published an article on the sort of traditional record-keeping rule requirements on our OSHA defense report, which is online. And in it, we highlight the top 5 common mistakes employers make with respect to the rule. And just as an FYI, the deadline under that rule is fast approaching. It's I believe submissions are due February 1st. So just something to be aware of, but we're going to be focusing for California on its adoption of the e-record keeping rule, which really tracks the Fed OSHA e-record keeping rule. So on September 19th, 2018, last year, the governor signed AB 2334, and that was largely in response to federal OSHA's recent proposal to eliminate the requirements that large employers submit 300 and 301 form data. So there was a proposal last year. Our firm submitted comments over the summer regarding this proposal to rescind the submission of 300 and 301 form data. So right now, I believe OSHA is still currently reviewing all of the comments that were submitted with respect to rescinding those two requirements for the 300 and 301, but to keep the requirement to submit the 300A summary data. So on October 18th, Cal-OSHA, in response to this, in response to OSHA's proposal, published an emergency proposed regulation intended to temporarily adopt and implement the federal OSHA data submission requirements. So those officially went into effect on November 1st of last year, and Cal-OSHA will now proceed with formal rulemaking since the regs, as I just mentioned, were issued under sort of were issued as emergency regulations before. So who must submit injury data? Any establishment with 250 or more employees is covered. So in addition to that, establishments with 20 to 249 employees are also covered, but only if they are in an industry that is listed in Appendix H of the rule. So we're not going to go through all the different industries that are included in Appendix H, but just by way of example, those include industries like wholesale trade, department stores, nursing care facilities, and rooming and boarding houses. Also, establishments that are specifically notified by Cal-OSHA to submit injury data must, of course, submit the data as well. As I mentioned, covered establishments must submit 300A data through OSHA's online portal, which it calls the Injury Tracking Application, or ITA. Okay, so when must the data be submitted? California imposed a catch-up provision to collect fiscal year 2017 300A data, even though the rule was adopted after the federal OSHA deadline for the 2017 data. So covered establishments were required to submit the fiscal year 2017 300A data by the end of last year, and must submit the fiscal year 2018 data by March 2nd of this year. So you can already tell that deadline is coming up fast, so you won't want to miss it. All right. So one major component of the California rule that is really interesting and sort of controversial is that it resurrects the former Obama-era safety and health rule pertaining to the statute of limitations. Although the Cal-OSHA Appeals Board decision in Key Energy Services held that Cal-OSHA cannot cite employers for failure to record if the violation took place over 6 months before the citation was issued, the new California rule now establishes record-keeping violations as continuing violations. So what that means is that the statute of limitation for record-keeping violations has been expanded by quite a lot to cover the entire 5-year period that the record must be kept. So this is a big caution for California employers, because even though there's no new requirement on employers, they should just be aware that Cal-OSHA can cite for records that are much older than they once were before sort of this resurrection of the Obama era rule. Okay, next we're going to speak briefly about shared liability for wage and hour violations. There are a couple interesting clarifications and new developments there. So we will start with the clarification of existing law on construction contractors' liability for subcontractors. So last year, California added a section to its labor code making construction contractors liable for wage claims against its subcontractors. The law also requires a subcontractor, when asked by the direct contractor, to provide information on the sub's work and its employee payroll records. And as a consequence of this, the law allows the direct contractor to withhold disputed subs if the sub fails to provide the information that's requested. But OSHA and California has recently passed Assembly Bill 1565, and that is to clarify that in order for the direct contractor to withhold disputed sums, he he must specifically set forth in the contractor with the sub exactly which documents and information must be provided. So this, as you might guess, provides greater notice to the sub about expectations and what documents and information might be asked for. And this bill became effective September 19th of last year. Okay, moving on to liability for port drayage motor carriers. So this is a new area of law involving liability. First, let's begin with what is a port drayage motor carrier. These are motor carriers that transport cargo and equipment to or from a port in California. Under the new Senate Bill 1402, liability has been extended to any customers of those carriers for labor law violations of the carrier employer. So the bill applies to customers of over 25 employees and includes customers that directly or indirectly engage a carrier. There is one exception for customers that hire a motor carrier whose employees are covered by a bona fide collective bargaining agreement that meets certain requirements that are set forth in the law. Under the new law, the Division of Labor Standards Enforcement must post on its website a list of the port drayage motor carriers that have any unsatisfied final court judgments, tax assessment, tax liens that may be released to the public under state or federal law. And so once a carrier is on that list, a customer of that carrier shares all civil legal responsibility for services received after that date. So this means that the customer will be jointly and severally liable with the carrier for future labor law violations. And so that's important to note. It's also important to note that even though the carrier has an obligation to provide notice of the posting to the customer, but a carrier's failure to do so is not a defense for the customers with respect to liability. So practically speaking, it'll be important for customers to refer to the Division of Labor Standards Enforcement website just to make sure it's not obtaining services from a carrier on that list, just in case of future labor law violations. Okay, next we'll speak some about some expanded protections in the areas of lactation accommodations, immigration status, and military status. So new requirements for lactation accommodations. There are new state requirements. AB 1976 expanded the existing requirements by requiring employers to make reasonable efforts to provide employees with use of a room or location, and this is critical, that is not a bathroom, and that is in close proximity to the employee's work area for the employee to express milk in private. The new requirements also include provisions on things like temporary locations, agricultural employers, and employers who can demonstrate undue hardship. It's also important to note that some cities, like San Francisco, have laws that are stricter than the state requirement. So just to give a quick overview of the San Francisco Lactation in the Workplace Ordinance is what it's called. Employers must provide employees with lactation breaks and a lactation location. They must also have a policy that explains how employees can make a request for lactation accommodations. The ordinance specifically defines minimum standards for the lactation accommodation spaces and requires that tenant improvements in buildings designated for certain uses include lactation rooms. And the ordinance also outlines best practices. So employers in San Francisco must abide by both, and if there's any conflict, of course, the stricter one should apply. Okay, so far as new limits on the admissibility of immigration status. Senate Bill 785 expands the limits on a person's immigration status. Specifically, it prohibits the disclosure of a person's immigration status in open court by a party unless he requests an in-camera or private hearing and the judge determines that the evidence is admissible. So there's sort of that two-step process to get immigration status admissible. It'd be a request in private, in camera, and also the judge determining that the evidence is admissible. And this bill went into effect in May of last year and will remain in effect until January 1st, 2022. Okay, moving on to the prohibition against discrimination of members of the military, which includes the reserves. So this was done by Senate Bill 1500. Under existing law, discrimination in employment by virtue of being a member of the military or naval forces, performing ordered military duty or training, or accepting a warrant or commission for service is prohibited. Existing law also prohibits the refusal of entry to public entertainment, places of amusement, and other kinds of business establishments for wearing the organization's uniform. And what the new law does is extend these protections to members of the Federal Reserve. Okay, moving on to now we're going to speak a little bit about new exceptions that have been carved out related to wage and hour requirements for the petroleum, motor carrier, and construction industries. First, there's an exception for rest breaks for the petroleum industry. Assembly Bill 2605 creates a temporary exception from rest breaks that are required under the Industrial Welfare Commission's Wage Order 1 for certain employees in safety-sensitive positions at petroleum facilities. So Wage Order 1 under this case, Augustus versus ABM Security, requires non-exempt employees to be relieved of all duties during rest periods. So this means they cannot be on duty to remain on call or carry radios or be expected to engage in other forms of instant communication. So if they're on break, they are on break. But under AB 2605, employees holding safety-sensitive positions at petroleum facilities need not be relieved of all duties during rest periods. To the extent they are required to carry and monitor communications, respond to emergencies, or even remain on the premises to monitor and respond, they are allowed to do that. But it's crucial to note that those employees must be given a make-up rest period, and the language is reasonably after the circumstances that led to the interruption have passed. So if in the case that they're not allowed to have that rest period, they must be given a make-up. But for whatever reason, if that is not possible, then the employee should be given 1 additional hour of pay at the employee's regular rate for a rest break that was interrupted or that the employee was forced to miss. So in this regard, they're allowed to not be relieved of all their duties, but they are being compensated by being given a make-up, or by that, if that's not possible, then the additional pay. Note that this only applies to employees covered by a valid collective bargaining agreement, where the agreement expressly meets certain requirements that are set forth in the law. And the bill went into effect in September of last year and will remain in effect until January 1st, 2021. I apologize for not advancing the slide, but this is everything we just covered. Again, if those employees in safety-sensitive positions are not given a rest period. They must be given a makeup or be given that additional pay, additional hour of pay. Okay, moving on to exceptions from rest breaks for certain commercial drivers. So AB, and this is a very sort of narrow industry or field, I'd say, but AB Assembly Bill 2610 allows a commercial driver employed by a motor carrier who is transporting nutrients and byproducts from a licensed commercial feed manufacturer to a customer in a remote rural location to commence a meal period after 6 hours of work rather than after 5 hours of work. So for the exception to apply, again, this is one extra hour of work that they're allowed to do before commencing a meal period. For the exception to apply, the regular rate of the driver must be no less than 1.5 times the state minimum wage, which we'll get to in just a minute, and the driver must also receive overtime. So there is also a temporary carve-out for the Private Attorneys General Act liability for the construction industry. So Assembly Bill 1654 creates this temporary carve-out for employees in construction working under a valid collective bargaining agreement that went into effect before January 1st, 2025. The CBA must also meet certain requirements that are set forth in the law and contain certain provisions such as relating to grievance and binding arbitration procedures. And this law will stay in effect until 2028. Okay, let's get to state and municipal minimum wage rates for the year. Okay, as of the first of this year, the state adopted a new minimum wage for employers with 25 or fewer employees. The minimum wage is $11 per hour, and for employers with 26 or more employees, the minimum wage is $12. Of course, there are a few municipalities that have enacted minimum wage ordinances that are higher than the state minimum. We've listed them all on this table, and as Andrew mentioned at the beginning of the webinar, these PowerPoint slides will be available, so I won't go through each of the cities individually. But just a quick note, some cities will experience rises in July, so that's something to watch out for. Some of those cities include Berkeley, Emeryville, Los Angeles, Malibu, Milpitas, San Francisco, San Leandro, and Santa Monica. So again, just something to be aware of that that not all of these change in January. Some of them will be changed again in July. Okay, and now I will turn it back over to Andrew, who will discuss some recent case developments.
Thank you, Beeta. So I wanted to discuss with you all some recent cases that I think are particularly relevant and will have an impact on how you all do business. And I will be brief so we can get to some of the questions at the end. But the one case that really struck me as earth-shattering was the Dynamix case that was decided earlier this year by the California Supreme Court. And what the California Supreme Court essentially did was it upended years of case law over the independent contractor question. So there has traditionally been a court decision by the name of Borrello that has applied a multi-factor test to determine whether a worker is an employee or an independent contractor based on the extent of control that's exercised by the business entity and among other various different factors, such as where the individual works, who supplies the tools, the expertise of the job, things like that. And so the multi-factor test traditionally allowed considerable leeway where you could on balance show that an individual is an independent contractor, even though some of those factors did not go your way in supporting the independent contractor relationship. Now, the California Supreme Court has found that in the context of the wage orders, and the wage orders in California law typically apply to wages, meal and rest breaks, and other other specific wage and hour claims. But in that context, if you're litigating that claim, there's what's called the ABC test. Whereas if you're litigating whether someone's a employee for workers' comp laws or other types of claims, you're still following that Borrello multi-factor test. So what's essentially happened is the Supreme Court, in a way, really simplified the analysis for whether an individual is an independent contractor for the purpose of the wage orders, whether the wage orders apply to that individual as an employee, or whether that individual is exempt as an independent contractor. And they had three factors. The first one here is that the worker is free from the control and direction of the hiring entity in performing the work. That's very similar to one of the factors in the Borrello case. But what's really unique here is the last two factors. One is that the worker performs work that is outside the usual course of the hiring entity's business. And in this court decision, the Supreme Court gave the example of a baker, that in a bakery, that if a bakery hires a cake decorator, that cake decorator would be working within the regular course of the business. On the other hand, a plumber hired by a retail store, that was another example, would be certainly outside the scope of the services being performed by the business entity. So this factor is very problematic, makes it much more difficult to classify someone as an independent contractor for a business. And then the third factor is whether the worker is customarily engaged in an independently established trade, occupation, or business of the same nature of the work performed by the hiring entity. And so the issue there is, is this a kind of legitimately established business that is incorporated, licensed, advertised, is engaged as a business entity, as opposed to a business just saying, hey, I want to hire you as an independent contractor, let's just enter into an engagement directly with you or have you set up a business. That might be suspect. Okay, so let's move to another really key decision. It's the EPIC decision by the U.S. Supreme Court. And in a real brief nutshell here, it ruled that arbitration agreements that containing a class action waiver are enforceable, or that can be, that are valid. And essentially in that decision, what they were considering was a decision by the National Labor Relations Board holding that the class action waiver in an arbitration agreement violated the National Labor Relations Act. So the Supreme Court came out and reaffirmed the validity of arbitration agreements throughout the country. And what's significant here is, many employers are moving towards arbitration agreements in light of the class action waiver provision that's allowed because of the rampant class action litigation throughout the state. But the one important carve-out is that if it is a PAGA, Private Attorney General Act claim, under existing law, that is not a claim that you can require arbitration over, and as a result, we're seeing many more PAGA claims in the state. Okay, so let's also discuss the de minimis rule and how it, I suppose, does not apply in California. And so under the FLSA and under some California law, there has previously been a recognition of this de minimis rule, and that's it if the work performed off the clock is infrequent or in insignificant periods of time, that it may not be precise enough for payroll purposes, that's not time that may be compensable. So if you have an employee that's spending 5 minutes checking his or her smartphone after work, is that time that needs to be paid by the employer? And so many employers have always viewed that very small increments of time may not be compensable. but it's been an open issue. The California Supreme Court came down and said, we don't do things like the federal courts, and here in California, all time is compensable regardless of the amount of time. And so it essentially allowed the claims in that case to go forward. But the court did clarify that the court wasn't making a broad pronouncement as to all types of wage and hour claims, and it suggested that there may be circumstances where time would not be compensable in small increments, particularly where it's irregular or rarely occurring, or in circumstances where it might not be, it might involve commute time or other issues. So there will be further litigation, I imagine, over this rule. And then another case that provided interesting insight over settlement agreements is that many employers will have no rehire clauses in their settlement agreements. And this court decision by a California appellate court found that the language that barred the former employee from seeking employment in the future with any entity affiliated with the former employer was an unlawful restraint on employment, and that violated California's prohibition essentially on non-competes. So you can still have language that would prevent the employee from applying or accepting employment in the future with the former employer, but having broad language, particularly where you have a large corporation that would include all related entities and subsidiaries, that would be unenforceable under this court decision. So wanted to cover some takeaways here. We always have so many new laws in California. We want to look at what should we do as a result. Should we be kind of revamping our operations? Are there particular areas that we should be concerned about? And the takeaways that I thought of were that you want to, first of all, develop a plan for complying with the training requirements. If you're a hotel, you need to look at not only the training requirements on harassment, but also the requirements over sex trafficking, human trafficking. And then you'll need to develop a plan to implement the training requirements to ensure that you comply. You'll also want to update your lactation accommodation policy to ensure that you have additional verbiage consistent with the new law in the state, just clarifying existing law. And then also, as always, you want to look at ways that you can enhance your anti-harassment policies. Do you have a policy that's compliant with existing California law that has very specific components? And also, how are you implementing that policy in light of these additional requirements that are being imposed under or as a result of the Me Too movement? You also want to review your employment agreements to ensure that you are not requiring employees to release potential claims of discrimination, harassment, or retaliation under the FEHA, or that they're not being precluded from disclosing information related to any such claims. So you'll want to carefully narrow those agreements in those ways. You also want to review settlement agreements for any language that might preclude disclosure of information related to claims of sexual harassment, sexual assault, harassment, and discrimination based on sex. And then you should always look at your new hire process. There's so many different laws in effect in California related to salary history inquiry that if you have in the past inquired into salary history, you want to not do so for applicants, and you want to remove that topic from your job application. And you also will need to ensure that you provide pay scale upon request by applicants who have conducted an interview, at least have a process to ensure that that's being complied with within your businesses. And then, of course, with your managers and supervisors, you want to ensure that you are properly training them and that they, I added this just because of how important it is that in the hiring process, it's important that managers and supervisors involved in interviews understand what questions are permissible and which are not, particularly around questions of protected status, that you're not unduly inquiring into those areas, and that they understand that, that they cannot inquire into salary history, and that there's also restrictions in California about inquiring into criminal history, and that there's a sequence for being permitted to do that. And because anything that your lower level supervisors do can be imputed to the business, they need to understand, just like HR, what the requirements are. And then, based on some of the cases we discussed, albeit briefly, you'll want to consider adopting arbitration agreements, or at least evaluate whether that would be appropriate for your business. There's many attorneys that take the position that all employers should have arbitration agreements because of some of the benefits available in arbitration. But it really is not a one-size-fits-all. There may be some businesses that are relatively small where there's not a whole lot of benefit in the class action front in having a class action waiver, but for a larger business there may be. Arbitration does involve a considerable expense in paying for an arbitration service and the arbitrator's fee, and that's an obligation that the employer has to pay. But then there's very significant benefits in having certain types of case, particularly ones that have inflammatory factual scenarios, to have those before an arbitrator and not a jury. We've all seen also that the courts have not been, at least in state court, efficient forums for resolving disputes, given our bogged down court system here in the state. You also want to review, and this is really important, to review your consulting agreements. Many companies have misclassified independent contractors. It's more of an issue now in light of the Dynamics case. So you'll want to go through and review those arrangements and consider, where appropriate, reclassifying those individuals to employees, or hiring a staffing agency to employ those individuals, or consider ending the relationship. There's various different scenarios you could consider. And then also, as always, audit your wage and hour practices to ensure that you're complying with the wage and hour laws, and also to prevent employees from working off the clock. In light of the Starbucks case with the de minimis rule, you could have situations where employees, when they're preparing to getting dressed for work, or after work hours checking their smartphone, might be performing de minimis amount of time off the clock. That might be something that would be compensable and be the source of litigation. So I wanted to address some of the questions that, and if there's any more, you can certainly type them in and we'll answer them for you. But there was one question very practically about what are the options for sexual harassment training. And so just to confirm that the compliance date for sexual harassment training under this new law is January 1st of next year. And so you'll want to prepare. And there are options on site. So if you have a large workforce and you have employees that you can organize en masse and get them into a meeting room and train them, it's much more effective to have the training live. And that's something that I would recommend, especially if you're in an area that has a history of problematic patterns of harassment. There'll be a real benefit in a live training. But you might be an employer that has employees that work at different locations, they have different shifts, and it may be difficult to get everyone together. So for a live training option, our firm does do harassment trainings. You can certainly reach out to us on that. You could also, there are HR services that you could reach out to for training options, or if you have someone in-house that performs a human resources function, has the appropriate background and skill to conduct the training, that's another option. There are some online services. You just need to be careful since there is the requirement that the training be interactive. Some of them can be costly depending on the number of participants, and what they would do is that each individual from their own workstation could log on and conduct the training. That may be a good option. Also, the Department of Fair Employment and Housing is supposed to develop a training module that will at some point be available on their website. That is something that you can then use, but you do keep in mind that there is a requirement that the employee have the option to ask questions and the questions can be answered. So you need to ensure that there is a line to someone in HR, or if you have outside counsel, or someone that can answer those questions. Just doing the training online is not enough. And then, there was also a question about if a headquarters is out of state, for example, in D.C., and you have a satellite office in California that's smaller, does this training requirement still apply? It's important to note that this requirement in California, at least historically, to have 50 employees in order to be obligated to conduct supervisor harassment training, those 50 employees have been measured by any place in the company. It could be out of state, within the state. So you're looking at the company historically as a whole when you're evaluating whether you're covered as an employer based on the number of employees. I suspect under this new law that it would be interpreted the same. There will likely be regulations that will be implemented. So at least as of the present, my recommendation would be if you have 5 or more employees anywhere, California or otherwise, ensure that you are providing this training. And then regarding, there was another question about the e-record keeping rule. And someone wanted to know whether there's a place where they can find the list of applicable industries. It is available on Cal OSHA's website, and there is an appendix that lists the industries by category. You can find it there. If you can't locate it, you can shoot one of us an email, and here is our contact information. And you can reach out to us, and we could certainly send that to you. And there was another question about the farm worker training requirement, and that is something that is independent, and if you are in that industry, that you would need to comply with independent of the general harassment training applicable to employers generally. And then there was another question about, it says our small business has only 6 full-time employees and 32 part-time, and calculating our minimum wage is the total number of employees counted regardless of full or part-time. It would be under state law, you would look at the total number of employees, regardless of whether it's full or part-time. There's a question about whether the online training has a Spanish-speaking option. I'm not aware of one presently. The DFEH may create a online Spanish-speaking option. I speak Spanish, and I do harassment trainings in Spanish. That's an option, but that requires someone coming out to the workplace. You could check back with the DFEH to see whether they have a Spanish language harassment training in the future. Okay, and there was also another question about whether the harassment training is required if you have employees that occasionally do work in California but work in other locations. That's a really interesting question. I'm not aware. I don't believe the new harassment law goes into that kind of detail. You could shoot us an email. We could certainly circle back with you on that. But they're typically, under most of the employment laws, there's been a requirement as a threshold matter that you have a certain number of hours or weeks that one is working in the state or within a municipality for those laws to apply to them. In any case, we appreciate y'all joining our annual update on California employment law. We certainly enjoy these issues and live and breathe them, and if you have any questions, ones that we may not have answered, or if any issues come up, you can certainly reach out to us. Thank you for participating.